Thank you, Mr. Chairman. Lieutenant Governor Stratton, I completely agree with you that it is the woman, not a bunch of politicians, who should decide her bodily autonomy. As I listen to all of my colleagues who support the Supreme Court's recent decision, they lose sight, in my view, intentionally. They lose sight of the fact that who should be making the decision about what to do with our own bodies, us or a bunch of politicians. Professor Bridges, you noted that Justice Alito chose 1868 as the historical basis for his decision in overturning Roe. And I agree with you. What is so special about 1868? And not only that, with the attitude or the approach of originalism, the justices who take that approach go all the way back to our founding fathers and pretend that they know what our founding fathers meant when they drafted the Constitution. I use the word pretend because who the heck would know what our founding fathers meant? Is there any reference to AR-15 rifles in our Constitution? No. So you noted that this is an outcome-based approach to our Constitution, and that is what Justice Alito applies. And when this committee had the hearing on the now Justices Gorsuch, Kavanaugh, and Comey Barrett, of course they said Roe was precedent. Every single decision of the Supreme Court is a precedent, but the one group that can overturn precedent is the Supreme Court, and they are very busy doing so. And in fact, I want to note, and I'm sure you're familiar, Professor, with the decision that was made overturning Abood, which was basically a 40-year-old Supreme Court precedent that enabled public sector unions to collect union fees. And in a decision called Janus, they just very summarily overturned that 40-year decision, thanks to the fact that Justice Gorsuch got on the court, because when Justice Alito died and they had a previous decision called Fredericks, it was a 4-4 decision. The minute Justice Gorsuch got on that court, it was a 5-4 decision overturning Abood. So that is what the Supreme Court is busy doing, overturning precedent. I don't know what's going to happen to other decisions that protect constitutional rights, such as what Justice Thomas signaled, Obergefell, the same-sex marriage protection. That could be out the window if the court applies to these kinds of cases a rational basis test rather than strict scrutiny. So, Professor, do you share the concern that I have about where this court is going to go with some of these other decisions that had earlier been made?
Absolutely. I am very concerned about where the court is going to go. The logic of the Dobbs decision, as the method of constitutional interpretation that the majority uses in the Dobbs decision, should frighten everyone who holds dear these rights that are necessary for people to live fully human lives with dignity in this country. Obergefell versus Hodges, finding that there is a right to marry someone of the same sex. If you interrogate what was happening in 1868, no such right exists. Lawrence versus Texas, finding that there is a right to be free from criminal punishment for consensual sexual contact with an adult. Such a right didn't exist in 1868. Griswold versus Connecticut, Skinner versus Oklahoma, Pierce versus Society of Sisters, Meyer versus Nebraska. I could go on and on. So these rights that are important for marginalized people, vulnerable people need these rights. Those rights simply were not contemplated by the people who drafted and ratified the Constitution in 1789, in 1791, or in 1868. So we should all be terrified.
Agree with you. We have a radical group of very conservative justices who are going to be making further decisions like this. I have a question for Dr. McNicholas. You talked about the chaos that has been created as a result of this decision, and I've been talking with some doctors in Hawaii. By the way, Hawaii was the first state in the union to decriminalize abortion before the Roe decision. So in talking with some of the doctors, there is even an impact, potential impact on what doctors, or soon-to-be doctors, are taught in medical school. For example, DNC is a procedure that is utilized for miscarriages. Could medical schools in states like Texas no longer teach doctors how to do DNCs because they may be accused of performing an abortion?
I appreciate the question, Senator. Yes, in fact, we will be creating an entire cohort of physicians who are underprepared to take care of pregnancy emergencies. I think it's important to note that medications and procedures are simply that. What changes is the indication. So the medications we use for medication abortion, the procedures that we use to perform procedures are the same exact medicines and procedures we use for people who are experiencing pregnancy loss.
Thank you, Mr. Chairman.
Thank you, Senator Hirono. Senator Blackburn.